I'm Vinny Politan. Great to have you with us tonight here on Closing Arguments. From where I'm sitting, the prosecution is scrambling right now. Absolutely scrambling in the case against Kim Potter. All because of what happened last week, which was their own witness getting up on the witness stand and saying that Kim Potter was justified in using deadly force. Now, that's not even the primary defense to this case, but it is powerful, it's important, and if the jury believes that, it's over. It's absolutely over. So what are you supposed to do as a prosecutor? Well, they're trying to get that testimony stricken. Now, we're going to talk about that in just a little bit with Chanley Painter. But think about what they're trying to do is get rid of the testimony of one of their own witnesses that they called to the stand. How does that look in front of the jury? If you, as the prosecutor, again, I say this all the time, your job as the prosecutor is to seek justice, which is the truth, okay? So you're going to now try to tell this jury, don't listen to what my witnesses were saying? And it may be objectionable, and legally, maybe the jury shouldn't have heard it, but they did. Are you going to argue that your witness was lying? I don't know. I mean, they're absolutely in scramble mode at this point. Now, another way that they can try to respond to all this, again, it's Officer Michael Johnson. He was a sergeant at the time. Now he works for the Sheriff's Department. He's a major. Was talking about what happened at that moment. He's on the other side of the car. He's the one who's leaning in. He's the one trying to make sure that Daunte Wright doesn't take off. And the question is, if Daunte Wright gets control of the car, is now Sergeant Johnson in danger of great bodily harm or potentially death? He said yes. And he said as a result, under Minnesota statutes, you're allowed to use the type of force, deadly force, that Kim Potter used. So another way that prosecutors are trying to attack this, I guess, is to attack whether or not he was actually in danger, whether or not there actually was that potential threat to his life or threat of great bodily injury. And now you're talking about splitting seconds in what was transpiring inside the car. As Johnson is in on one side and Kim Potter and Lucky are on the other side, and Kim Potter is yelling, taser, taser, taser. Is Johnson still in the car? Is he out of the car? And what prosecutors want to do is get Johnson out of the car. You get him out of the car, and now all of a sudden, no longer is he at the risk of death or great bodily injury. And then all of a sudden, deadly force is not justified. And now we get back to square one of the trial, which is, okay, this is an accident. Is it so egregious that it's a crime? But you don't even get to that part of the analysis if this is a justified use of force. So let's take a look at what happened today. Brent Peterson, BCI, Special Agent, Bureau of Criminal Investigation, again, called by prosecutors, and prosecutors now trying to get into, is he in, is he out, is he in danger, is he not in danger? Take a listen.
Okay, you'd agree the video is now paused at 2:02 and 0 seconds, correct?
Correct.
Can you see where Officer Lucky's body is at this time?
From this video, the bottom video there from the squad camera, it appears that his feet and legs are outside the vehicle on the pavement, and his torso is kind of leaning towards the open door.
If you look at the top left corner in Officer Potter's body on camera, are Officer Lucky's shoulders inside the vehicle or outside the vehicle?
Based on the view of this video, it does not appear that his shoulders are in the vehicle.
Okay. Did you also examine Sergeant Johnson's position at various points during this incident?
Your Honor, I object to this. The video speaks for itself. The time speaks for itself. This officer's view of it should not be, the jury's the one that decides. It's not this officer. He's not an expert of videos.
Right. Counsel, will you please?
You'll recall in Derek Chauvin's trial, we had sort of the same thing. We had different witnesses describing the video that we've all seen, saying what they saw. Well, here, the defense objecting to that. Time to hear from the judge.
Counsel, let's talk about what we're doing from here on out with this witness. I am not going to allow BCA agents to get up on the stand and tell the jury what a video shows. The video is the evidence, especially when it comes through the mouth of a BCA agent. You know, the jury may get the impression that this person is an expert at looking at video. The jury's going to have that video. They can look at it as much as they want in the jury deliberation room. The state has the right to argue that Officer Johnson wasn't in danger of getting dragged by the car in final argument. That's totally fair game. You know, the state can argue and stop the video in final argument and say, look, both of his feet are on the ground. That's all fair game, but I'm not going to let the witnesses tell the jury what's on there. Okay?
All right, you heard the judge. The video speaks for itself. So now let's take a look at the video. And this is actually 3 different perspectives all at once. At the moment of the shooting, one of those perspectives will freeze because we don't show that on television here on Court TV, but you'll see the rest of the videos continue. So let's take a look for yourself. Here it is, the actual video that the jury will have to decide. Was he in danger or out of danger at the moment that the gun was fired?
Just stay back. I'll tease you! Taser, taser, taser! Ah, he shot me. I just shot him. Dead? Yes!
Jury will have to figure it out. Let's bring in Court TV legal correspondent Chanley Painter, joining us live tonight from Minneapolis. Chanley, this is really a huge issue now in this case, not an issue that I anticipated being a part of this trial. Now it is the focus of this trial. Tell us a little bit more, though, about what Sergeant Johnson said, because he testified on Friday about all of this, and he is the person that we're talking about here.
Yeah, this is a huge witness for the prosecution because he's there at the scene. But on cross-examination, like you said, Vinny, the defense really able to score some major wins that go to its theory of the case, that if Kim Potter even intended to use deadly force under those circumstances, it would have been authorized and justified given what her co-workers, her colleagues there at the scene said. Not only did Michael Johnson, the former Brooklyn Center police supervisor, but also Lucky, her trainee that day, also corroborated that testimony on day 1 of this trial that he would have also used a taser, that his life was also in danger had Daunte Wright been able to flee without force being used. But let's take a listen back to Friday when Michael Johnson told this jury on cross-examination that he felt that this was appropriate use of force.
She said, oh my God, I'm going to go to prison. Do you remember her saying that?
Yes.
And Lucky said, according to the video, no, you're not. No, you're not. Kimberly says again, oh my God. Lucky says again, no, you're not. You remember that?
I don't.
All right. Then you said, Kim, the guy that was trying to take off with me in the car. You agree you said that, right?
Yes.
And if he had taken off with you in that car halfway, what would have happened to you? What would you think would be the worst that would happen?
Probably dragged.
Dragged and what?
Injured.
Seriously injured, maybe even dead, right?
Yes.
And if that were the case, would an officer in your position, with Officer Potter trying to stop him from resisting with you and resisting Lucky, would it be fair for that officer to use a firearm to stop him?
By state statute, yes.
By state statute.
Yes.
There's a statute that says if you, to avoid death or grave bodily harm, you have a right to use deadly force, correct?
Yes.
And you're aware of that statute.
Yes.
This examination went on, Vinny, for this Officer Johnson to say, yes, a vehicle can be considered a deadly weapon, and force meeting force with deadly force with deadly force. That's what the defense wanted this jury to hear. Now, the prosecution tried to rehabilitate Johnson, of course, Vinny, with saying, you didn't tase Daunte Wright, you didn't use your firearm, you actually weren't drugged in the vehicle when it did, in fact, take off. But ultimately, the takeaways there are some major points for this defense.
Major, major, major points. I posted a video on social media talking about how different this is than the Derek Chauvin trial, where no member of law enforcement was coming forward saying that was proper, what Derek Chauvin did. I mean, it was tough. I couldn't even get a guest on the show to talk about that. This is a much different situation where you've got the officer at the scene saying, yeah, this was proper use of force. So now the state fighting back, they filed some papers, some motions trying to get the jury to disregard all of this?
Right. If you notice in the sound you played, there weren't any objections lodged at that moment by the prosecution for a witness, a layperson witness, not someone offered by the state as an expert. He was an eyewitness at the scene. He was able to reach these conclusions about the use of force. So today the prosecution filed a motion to preclude layperson opinion testimony from this trial, Vinny. Here's a look at part of that motion. It says on December 10th, 2021, defendant elicited testimony that her conduct was authorized, quote, by statute. This is precisely the type of factual question that is exclusively within the jury's domain, as the jury will have to determine whether the defendant was authorized to use deadly force. This motion asks for some relief, Vinny. They want Officer Johnson's testimony about that stricken from the record. They want Judge Chu to preclude any more witnesses from testifying about this ultimate conclusion that they think the jury is the one to decide whether or not Kim Potter's actions were reasonable that day. And they want some sort of curative instruction, or the judge to read some sort of instruction to the jury to disregard Johnson's testimony and how to handle that as they go back and deliberate.
Unbelievable developments. Unbelievable. All right, Chanley Painter, we'll get back to you in just a little bit. Let's bring in our think tank. Joining us tonight in Tampa, Florida, criminal defense attorney Teresa Jean-Pierre Coy. In Marietta, Georgia, civil attorney, former police officer Lance LaRusso, and also in Atlanta, Georgia, criminal defense attorney Michael Bixson. Welcome to you all. Teresa, your thoughts. Is the prosecution scrambling? Is this game over if the jury believes the prosecution's own witness?
If the jury believes the prosecution's witness, it is game over. And, it's still, it was crazy. My first thought was, were there depositions taken of this officer to get its ultimate conclusions on this? Because how was he able to even come out and say that? It was just really interesting to me. But I definitely think the prosecution is scrambling and they need to figure something out. I don't think the judge is going to issue a curative instruction or, let them do whatever it is that they're trying to do. I don't believe the judge would do that. It was their witness and he testified, and they just going to have to deal with the testimony that came out at trial.
Yeah, Lance, this is kind of like an awkward situation for prosecutors, right? Don't listen to the witness, the eyewitness who we put on the witness stand. They weren't objecting when it was all happening, and now you're trying to, even if you get this jury to disregard it, I mean, what are they going to think? The jury's like, well, the prosecution doesn't want us to consider the evidence that they're presenting in their own case?
Well, listen to everything else he said, but not this little thing that he said. That's the problem they're stuck in. There's two other issues here that people are overlooking. If Kim Potter was justified in using deadly force, then she was justified in using less than deadly force. And if Daunte Wright was driving off with a law enforcement officer in his car, he's committing a kidnapping. And at that point, an officer can use deadly force or non-deadly force to stop that forcible felony. Now, if you look at the officer who was on the passenger side, His elbow misses getting caught in the door frame of that car when Daunte Wright drives off by a couple of inches. So this idea that they're going to make a distinction between the officer being in danger and not being in danger is like stepping off a gangplank into a moat of alligators. They're in trouble.
Michael Bixon, the whole thing surrounding this issue, it surprised me because I thought this entire trial was going to be about Officer Potter made a mistake. Is the mistake a crime or is it not a crime? You know, what level is this mistake? How egregious is it? And now we're talking about a much more traditional potential part of the defense, which is justified use of force, even though she didn't mean to use it.
Absolutely. And, you know, I usually don't like to have competing theories in a defense case. I like to have one theory and stick to it. But in this case, now that it's come out from the prosecution's own witness, I absolutely would bring it up in closing. And I don't think that the judge is going to, you know, issue any type of limiting instruction. I think that that time has come and gone. And for the jurors, I think as well, I think that, you know, they listened to the testimony. And I really do think that they're going to take it into consideration when they're making their decision. But for the defense, you know, I think it's great for them because it does provide an extra avenue to get out of this. And, you know, based on the testimony you heard, I think it's pretty credible.
All right, we're going to talk more about this throughout the show. Our think tank staying with us the whole hour. When we come back, though, a hearing today for the accused Oxford school shooter. We'll show you what happened and what the attorneys were asking for. Like, they want this accused mass murderer out of jail. We'll show you what the judge had to say after this.